You're gonna have to read off the heading again. Say this is the matter is a continuation at the end.
Pardon?
You have to read off the heading again.
Oh, I thought you said something. That's not. I mean the
Why is he not playing?
He's playing blues. I think there's nobody on yet.
Okay.
She wants a call before.
What she say?
Yeah, she wants us to be called.
Okay.
I don't know when we're ready. But I don't want to start. You have to check YouTube to make sure it's called. So if you can see them on YouTube, my recommendation is that you can start. Because if you just call out, so we're losing.
Morning. Sorry for the delay.
No problem. I was beginning to think it was me.
No.
Right.
About to start in a minute.
Okay.
You're gonna need it when I pull out. Shouldn't see it yet. Good morning. Wednesday, the second day of December 2020, Court Commercial Court 2 at 9:30 a.m. before the Honorable Justice Sybil Williams. Appellate Jurisdiction 219, number 33. Dr. Asad Qamar versus the Bermuda Medical Council. Mr. Stan Stevens for the applicant, Mr. Curtin Francois for the respondent.
Okay, good morning, everyone. Can everyone hear me?
Good morning, my lady.
Good morning.
Yes, let me firstly apologize for the delayed start this morning. This platform of hearing is still new systematically to the court, and unfortunately that requires many unforeseeable steps before we can start. So there we are, and here we are now. I think we agreed that we would start closing speeches this morning. So shall we hear from you, Ms. Francois, first?
Yes, my lady, thank you. Now I've moved my computer a bit closer. I just want to confirm that you can hear me a lot clearer.
Yes,
I was
thank
thought
you.
it was a little.
Yeah,
Okay, thank
thank
you.
you.
Okay, great. So my lady, I want to start by confirming that you have the skeleton argument of the
Yes.
respondents
Yes,
and also the bond of authorities.
yes,
Okay. So my lady, I'll start by saying that the main issue in this appeal is whether the committee was correct in concluding that the appellant was not of good character and therefore was not a duly eligible applicant. So firstly, how should the court approach the appeal? Now, as the respondent has outlined in their skeleton at paragraphs 30 to 35,
mhm,
it's our position that although Order 55 Rule 3 of the Rules of Supreme Court provide for a rehearing, this does not mean that the court should form an opinion on good character regardless of the Bermuda Medical Council's opinion. So I'll take you to the case of Gosh. That's cited at paragraph 31 of the skeleton. Now, I believe my learned friend has already read the paragraph that I have listed there, which is paragraph 33.
It took me to paragraph 28.
Sorry, I mean in relation to Gosh, because at
I see.
paragraph 31 of Gosh,
Yes.
I have there listed paragraph 33 of the judgment. I can read it again.
Mhm.
I was just indicating that I believe it was read, but I'll read it again. I can direct the court to the tab 3 of the authorities bundle,
Yes.
and that's where this paragraph lies. So I'll read paragraph 33. Practitioners have a statutory right of appeal to the board under section 40 of the Medical Act 1983, which does not limit or qualify the right of the appeal or the jurisdiction of the board in any respect. The board's jurisdiction is appellate, not supervisory. The appeal is by way of a rehearing in which the board is fully entitled to substitute its own decision for that of the committee. The fact that the appeal is on paper, and I recognize this appeal is not on paper, and that witnesses are not recalled makes it incumbent upon the appellant to demonstrate that some error has occurred in the proceedings before the committee or in its decision. But this is true of most appellate processes. And I also want to take you, my lady, to paragraph 34, and you actually have to look in the authorities for that because I don't have it listed in the skeleton.
Yes.
So if you go to tab 3, paragraph 34, I just want to turn over the page because paragraph 34 is a long paragraph.
Yes.
And I just want to bring the court's attention to what's listed under the quote from the Evans case.
Yes.
Right. So that starts, for these reasons, the board will accord an appropriate measure of respect to the judgment of the committee, whether the practitioner's failings amount to serious professional misconduct, and on the measures necessary to maintain professional standards and provide adequate protection to the public. And we also want to take the court to the case of Luby.
You're not going to read the rest of the paragraph, or is that just?
My learned friend had read it. I just wanted to direct that part.
That's where you would place your emphasis. Okay.
I would place my emphasis there. I know that I can read the remainder. I know that my learned friend.
That's fine. I wasn't sure if that was an oversight. That's fine.
No, I just wanted to put that forward because I know that we had the rest of the paragraph that was put forward.
Thank you.
Right, so I'll also take the court to the case of Luby, which is at paragraph 33 of the skeleton.
Mm-hmm.
And this case is at tab 7 of the authorities bundle. The court wishes to go there, but I'll just read it directly from the skeleton. So this is actually a case in relation to a tenant of a local housing authority. Mm-hmm. They argued that the increase in rent was ultra-virus as they had not taken into account his personal financial circumstances. And alternatively, that the increase was unreasonable. This is just a factual background. Mm-hmm. So at paragraph 33, regarding the limitation of a court of review as opposed to a court of supervision or original jurisdiction, in Luby, Diplock J, Lord Justice, as he was then stated, reasonable in the context in which it appears in section 111, subsection 1 of the Housing Act 1957 is, of my view, to be construed as the converse of unreasonable in the sense in which it is used by Lord Green, Master of the Rolls. The court's control over the exercise by a local authority of a discretion conferred upon it by Parliament is limited to ensuring that the local authority had acted within the powers conferred. It is not for the court to substitute its own view of what is a desirable policy in relation to the subject matter of the discretion so conferred. It is only if it is exercised in a manner which no reasonable man could consider justifiable that the court is entitled to infer. So basically, my lady, by stating both of those cases, we would put before the court that the Bermuda Medical Council decisions deserve a certain amount of respect unless they are found to be plainly wrong. So we say that the court can take, the court can be fundamentally assisted by the professional judgment and experience of the committee members when seeking to determine the aspect of good character.
Tell me something, Ms. Francois, would that vary according to the issue that is under examination or in dispute? So for example, if the challenge before me was in respect of the qualifications of Dr. Qamar, I would necessarily give a lot more maybe deference or regard is probably the better way to put it, to what the medical professionals had to say about those qualifications. But where we're talking about something such as the issue of good character, which doesn't really import the need for a particular medical professional expertise, how much reliance would I have under those circumstances in contrast to an issue which requires more professional input from the medical field?
Well, my lady, the medical council has indicated that doctors, medical professionals are held to a certain standard. And this is a standard that they themselves would expect of a professional. So our submission would be that you actually can take guidance from them. This is what that professional statutory body would expect of one of its members. I think that can probably be said with a number of professions, but medical professionals, just like legal professionals, are held to a certain standard. So the medical profession—
It's a general professional standard. Where you're concerned with something like good character, which is why you're able to put authorities in front of me that do not necessarily refer to the medical profession. When you're concerned with the concept of good character, that is pretty fluent amongst most of the professional bodies, I would think. Or am I wrong?
So my lady,
a different standard of good character for the medical profession than there would, for example, for the legal profession or for any other discipline?
So what I'll do, my lady, I was going to approach the public confidence, public opinion aspect. Mm-hmm. And that I would say is something that was raised in the case of Lane. Mm-hmm. So I'll take the court to Lane right now.
Okay, thank you.
So Lane is at tab 1.
Yes.
So at paragraph 43, and this is Lady Arden. And I recognize that this is in reference to public confidence and public opinion, but it does make reference to what it is that you're asking.
Okay.
So what I'll say here is that paragraph 43, I would say it starts in the middle of the paragraph. It is not enough. Mm-hmm. This is what Mr. Stevens read yesterday. Mm-hmm. It's not enough that the public would misguidedly not have confidence in a particular candidate. It is not part of its function to assuage public opinion. So the public confidence requirement is not inevitably satisfied by adducing evidence of the opinion of witnesses. But I wanted to move on to paragraph 43. That paragraph wasn't put before the court. So it says the existence and scope of the public confidence requirement may vary according to the profession under consideration. And then it says in the case of the admission to the bar, it is relevant because, as the judge put it, attorneys are the guardians of fundamental freedoms. So what we say is that Dr. Ross Dr. Ross at paragraph 100 of her statement. In that same paragraph, she refers to the confidence of the public in the medical profession as a whole. So at paragraph 44 of Lane, Lady Arden states that the scope of this may vary according to the profession. And it was determined that, I'll skip over that because I just went through the actual paragraph. So we would argue that public confidence is relevant to medical professionals as they are required to provide a quality service and use resources efficiently for the benefit of patients and public. So what I'm trying to say there is that it's not just a general oversight. Medical professions, legal professions would be held to a higher standard. And this
Right.
is why I
So
say,
if there's a comparison that you can draw to the exclusion of other professions, but you see some parity between the legal profession and the medical profession, then I would find myself asking you again, as we sit as members of the legal profession, how much regard would I necessarily have to the decision of the board on an issue like good character, where the very profession within which I have the expertise, within all those who appear before me have the expertise, are we not just as competent and able to judge the question of good character as a medical profession? And is there any real difference in the threshold for good character between the medical profession and the legal profession?
I would have to say the answer is no, not necessarily a difference between the character references in the medical profession and legal profession, but the legal profession has attorneys and Bermuda Bar Association and persons who can confirm whether or not an individual is acting in the way in which those professions require. So I'm trying to put before the court that I accept that there is a generalization as it relates to good character, but the particular bodies can state what it is that they expect of one of their members. So
we're talking about, so maybe I should hear from you first on really what is under attack evidentially in terms of Dr. Qamar's good character, because on your written submissions, I gained an impression that the real issue is how he completed his application form in its initial process. That's the initial application that have been shown in the evidence, which would, in accordance with the rules, have been sent to the permanent secretary for transmission onto the medical council.
Yes.
So
yes,
is that really the heart of the factual criticism?
Yes, that is the main one. The other ones became secondary, but that was the main issue, that he did not provide proper fulsome answers on the form.
So what would be unique to the expertise and the competence of the board composing of medical practitioners, at least in part? I'm saying the board loosely, the medical
committee.
Council and the credentials committee. What is it that what competence, what special competence would they have in dealing with such a narrow issue as to good character, and on this case, as to how he filled out an application form?
Sorry, my lady, I'm just trying to find the reference, but basically in Dr. Ross's statement, she indicates that they receive a number of these applications. And so by viewing these applications, they would expect a certain amount of information, honor, and integrity to be provided in relation to them. So I would say that on the basis of their experience with having reviewed these applications, it would be able to guide the court in that respect.
Mm-hmm. Are you going to be taking me to Dr. Ross's statement at any point?
I am. I'm just.
You don't have to do it now. If you're going to do it in due course, we can come back to it.
My lady, I just finished with the case of Luby. I wanted to address you on the case that my learned friend put before the court. Mm-hmm. This is the case of PAPS v. Medical Board. It's not in, it's a loose paper. It's not in his.
Oh, is that what was emailed to the court?
I believe so, yes.
The
Australian case.
All right. Yes, I have it.
So my learned friend took the court to paragraph 32 to 34.
Mhm.
And I just want to take the court also to paragraph 36 of that same case. And this is, he provided this case to suggest that there were 3 different aspects of these types of appeals. So it was this first, an appeal was strictly so-called, second was a rehearing, and third was an appeal de novo. But at paragraph 36, it states, the decision under appeal is that of a specialist tribunal and involves consideration of matters of professional judgment about the appropriate conduct of the practice of medicine. As such, this court should be careful not to intervene to substitute its own view unless a clear error in the tribunal's decision can be demonstrated. And I understand what your ladyship is saying in relation to whether or not it's a specific medical procedure or qualifications. But again, I reiterate that as the medical board have viewed a number of these applications, it's a certain honesty, integrity they would expect and would have seen in the applications before they. So
They
that
would
is
have
experience.
they would have the advantage of having the ability to compare application processes between, I suppose, between different applicants.
Yes.
I've seen a volume of previous candidates for or applicants for a registration number and how they've filled out these forms. That's
yes. So that's yes, that's the submission we're putting before the court. They would have the relevant experience.
They know how it's usually done.
Yes, they know how it's usually done. Thank you, Maria. So basically, just by pointing out that paragraph, I say here that even here, the Supreme Court of South Australia suggests that the court should give credence to the findings of the specialist tribunal. Now, the evidence of Dr. Ross, what I would say is that the evidence of Dr. Ross, Dr. Peekball, and Dr. Doherty, they weren't questioned on their evidence. They weren't cross-examined. So we would submit that their evidence be fully accepted. For this reason, it wasn't my intention to take the court through the entirety of their evidence as it remains unchallenged, but I'll be guided by the court, but I would take the court to the pertinent aspects of the evidence. Yes? Okay. So Dr. Ross's evidence is contained at page 668 to 695.
Okay, let me get her evidence 1 minute. Yes.
Okay, my lady. So at page 675, paragraph 27.
Oh, is this in the hearing bundle?
Oh, yeah, sorry.
Well, I have a separate binder, witness statement of Dr. Ross. So you've just compiled, so I need not go beyond the hearing bundle.
No, sorry. It's in the hearing bundle.
That's fine.
Apologies.
No, that's fine. Thank you. All right, what's the page reference?
I took the court to page 675,
Yes.
paragraph 27.
I have it.
Right, and here she states that serious concerns remain today in the committee's professional judgment about the appellant's lack of transparency and integrity when he filled out and personally signed the BMC application form for initial full registration as a medical practitioner. And she goes on to paragraph 28, that the form at the top states that you must complete every section of the application and submit the original application and all required supporting documents. And if more space is needed to fully answer the questions, attach additional sheets with typed responses. And Dr. Ross states in the initial interview, the applicant's application, it appeared clean, and he was deemed to be well-trained and experienced, and that's at paragraph 29. So I want to stop and point that out, because the suggestion was that the board from the outset seemed to have had an issue with the appellant, but they do recognize that initially it did seem that he appeared clean, he was well-trained in an experienced position. But they go on to say that over time, a different picture was painted with respect to his character. And we say the appellant did not provide truthfully full answers to questions 3 and 4 in the application. Now I'm sort of paraphrasing now. Apologies.
So let me ask you this: the real, as I see it, the real dispute between the parties is this: you say he was dishonest in his initial presentation of his professional profile when he submitted the application, the first application in writing.
Yes.
But Dr. Qamar's case is that that was a 2-page document, a large portion of which called for yes or no responses. And it was so simple in form and in content that it was reasonable for him to anticipate that there would be a second tier of the process where he would be probed, and where he would have the opportunity to fully explain things such as the settlement agreement, the exclusion from Medicaid and Medicare, the keep Tom, I think they called it, claims. So his case is, it would not have been reasonable for him to divulge all of that complex information in the initial application process. And I think on the appellant's case, because these documents are in the public domain, he would argue that surely he was not trying to hide it, evidenced by the fact that when the application process advanced, he was quite forthcoming with all of this documentation. But that the medical counsel's criticism of him in not having divulged what now before me in a court bundle goes up to 1,000-some pages. It would not have been reasonable for the medical counsel to expect for all of that type of information to have been divulged in the very initial process of the registration, the application for registration. That's, as I see it, the real issue. Not
Right.
all of the information that you have in front of you, you being the medical counsel, was delivered by him. It was just at a stage which you would criticize was belated and ought to have been done somehow appendixed to the 2-page application form.
So, my lady, I addressed that.
Mm-hmm.
The issue here is that he says that he expected there to be an interview, and at that time, he would provide the information. So at that time, he would have, what we say, provide the truthful answer. But the
would have been in a position to explain himself that, well, it's, there is a settlement agreement. I have not been sanctioned for any disciplinary action, technically, because, and then he could explain all of himself, but it would at least get him through to the stage where he could explain all of these complex matters.
Right, but our position would be, well, could have taken him 2 paragraphs to at least say, you know, FYI, I'm in the middle of a settlement offer, I'm in the middle of a disciplinary action. He didn't have to attach 1,000 pages to the application at that time. He could have simply mentioned it. So at the end of the day, it's quite interesting for him to say, oh, wow, if they had an interview, I would have told him then. Well, clearly he recognized, if he would have told them then he recognized that it was something that was important or pertinent to provide. So I don't think that he can put before this court, well, it would have been too hard to provide the information. It's too much.
How voluminous was the document, the supporting documentation? I don't have that in front of me, but I would imagine it's not a factual dispute. What type of documentation, or what level of, what kind of volume of documents did you have? It is initial application.
It is, well, the information was provided bit by bit, but over time it did become voluminous.
So when the 2-page, so let me get a few things straight factually. When the 2-page application form was submitted, was that submitted to the permanent secretary?
I don't believe so. I'll have to confirm.
Was it submitted directly to the council?
It would have been submitted to the council. I need to confirm whether or not it went to the permanent secretary.
Okay. And
I can find that in the
with that initial submission, were there supporting documents?
His qualifications would have been provided.
Do you have any sense as to whether or not that was another 2-page document, or were there several articles about his qualifications? Was it a binder? Do you have any sense as to how voluminous that paperwork was?
I believe it's in the actual bundle.
So a question I put to Mr. Stevens yesterday, but he wasn't able to assist me. I won't waste too much time on it, but I would like to have some general sense as to what that initial submission looked like.
We'll definitely, I just have someone looking for the actual reference.
Okay, that's fine. So you can come back to it.
Yeah. Okay. All right, so basically, I hope I've answered your ladyship's question in relation to the amount of documentation that he says he should not have had to have provided.
And your real response is that he made absolutely no reference whatsoever, and he should and could have found some, if even succinct manner of presenting the reality, but he could have disclosed that and should have disclosed it.
Yes, he could have and should have, and recognized that he should have, because he indicates, well, I just would have done it in an interview. So that's how we know that he recognizes that this is information that he should have provided. So if I can take your ladyship back to.
Sorry, Ms. Del-Francois, before we leave that point, was there, because I don't see any interview process set up in the statutory scheme. It seems that what happens, not necessarily known to Dr. Qamar, but it seems that what would have happened is the medical council through the credentials committee would have considered the application on the papers and then made a determination according to the criteria for which he failed on good character. After, had he not failed, let's say that they approved the application, then the only next step, as I understand it, I referred counsel to Section 8 yesterday. I don't know if anyone has had an opportunity to look at it, but on my understanding of what is set up under the Act is that the only thing that would have happened if he had been approved in that process would have been a qualifying exam by at least 2 medical practitioners.
Well, the information that I have from the medical council is that after they've been approved for registration, they have an interview with the applicant. And they do that.
Is that pretty standard?
My understanding is that it is standard. They've advised that they have interviews with all applicants after they've been approved for registration.
Okay, so he, Dr. Qamar, would have been correct in his impression that an interview was forthcoming if his paperwork have been approved for registration.
Yeah, that would have been, but after approval, yes.
Okay.
But I would hesitate to say that at that time, he would have thought that he can provide the information, this pertinent information, because that would be after his approval. And surely he wouldn't expect to provide the information at that time.
Tell me something. How would one, in a position like Dr. Qamar, who has, there are many nuances to his claims, the administrative side in terms of Medicare and Medicaid, and then the more serious aspect involving the fraudulent insurance scheme, I'll call it that very loosely. How could he have, or let me put the question this way. Would it have been at all reasonable for him to have concern that his defense to these kinds of claims could not possibly be understood without further dialogue from him?
But it would have been open. If that was his concern, there's nothing to stop him from contacting or making contact with the BMC. Now he suggests
he complained about that quite bitterly yesterday, that he was not able to have that direct contact.
But we would submit that there is nothing in the evidence to suggest that he tried to contact him. He says he tried to make contact. There's nothing in the evidence to show that he did try to contact him.
Well,
it would not have been
he
difficult.
said when under cross-examination yesterday that he was told on numerous occasions that they would not speak with him directly and that they would only speak to his prospective employer.
Well, we would say that there's nothing, we have nothing to suggest, no evidence to suggest.
You have his oral evidence.
Right, I hear what the court is saying, but what I'm putting before the court is that whilst he provided that oral evidence in court, there was nothing in our
document. You haven't challenged it. Where's it controverted? He's raised it in his oral evidence. Is there any evidence that you would point me to that would challenge that position?
Well, simply to say that the chief medical officer has not indicated that she received any correspondence from.
She does. Well, I mean, whether she hasn't, but he has in his evidence during his oral evidence yesterday. He was quite clear, emphatic, that he attempted to have this, so much so that it made him now go and get counsel when he was unable to understand why it was that he had a registration number and yet he had not been approved. He, all of the, because he couldn't communicate directly with the counsel. So I definitely have evidence before me, as I see it, that he did not have that ease of communication with the counsel. And his position is that he would like to explain it. And in a 2-page application form, which could have been appendix to many, as many documents as he wanted to in theory. But is it not reasonable for someone in his position to want to have the opportunity to explain his position and explain the complexities and the nuances of where he is and the status of these claims? Had he just simply written it down on the form, which he did, because as far as he's concerned, he gave technically true answers, he still could have elaborated in the interview.
He still could have provided the information and indicated, however, there's a lot of information to be provided. I'd like to speak with someone further about it. But he said nothing.
He presumed that opportunity would come to him. He would have the opportunity to speak because that would be in the interview.
But again, it still begs the question, if it was the case that he was willing to release it in the interview, why would he not have told him in advance? It would have been simple to just say, I have a few matters, but I'll identify them further in the interview that he believed he was going to have. But he said nothing.
Okay, so let's consider that for a moment. Is that evidence which impugns his good character, or is that a poor judgment or an or I don't want to necessarily describe it in any term because I don't want to give you the impression that I've taken a view on it. I have not. But I would like to hear you answer to the things that I've heard the respondent, the appellant raise. And I think if I understood Dr. Qamar's evidence and his counsel's submissions, at the very highest, it was a judgment call. But is that really something which impugns good character when all of the information was in any event disclosed?
Well, the counsel would say that a person with his experience, and in fact, Dr. Qamar indicated that he's filled out a number of application forms. I think he said hundreds over his 30 years experience. And I believe he said that in cross-examination, he's filled out hundreds in his 30 years of experience. So he would know, and he should know, that in completing these application forms, he should provide honest and fulsome answers. And this is what Bermuda Medical Council were concerned about. Regardless of what the application form indicated, he, as a professional, experienced professional, should have provided the information. And if he felt that he needed to elaborate, he could have indicated that when he provided even a summary, a 2-paragraph summary, to say, this is what's happening. I'll speak to you about it further, but I just wanted to advise you. Now, the reason why I say that he had an inkling that he should have provided that information is because he specifically asked Dr. Bazin how he should answer. If he felt that it was a simple yes or no question, why did he need to consult someone as to how he should answer it? And we say that's because he knew that he probably should have provided that information from the outset.
He had adult and he resolved it. He had adult and then he resolved it. But let me ask you this, Ms. Francois, what do you say about the evidence in terms of the question of truthfulness? When Mr. Stevens was addressing me in his opening submissions, I queried whether or not he could fairly say that Dr. Qamar had provided all of the information in its fullness. But do you go further to say that not only was the information incomplete, but it was dishonest or untruthful?
Yes, it was untruthful.
Okay, so would it help for you to, I mean, you were quite careful in your cross-examination to take him to cross-reference him to passages which I think it was number 4 in particular on the application form. So I'm looking at the application form, page 641. Is that right?
Yeah, 641 and 643.
Okay. And then in your cross-examination, you took him to page 1004 for the discipline narrative.
Yes.
And then I think you drew to my attention the date of the action taken was the 28th of February 2019.
Yes.
And then the final disciplinary action as it's set out in the final box, caused a fine in the sum of $5,000 in continuing education. So that was on the 28th of February 2019. The application form preceded that final disciplinary action.
Yes.
And so at page 643, looking at, I think it was question
Or,
4,
yes.
or no, question, what
Oh,
disciplinary?
you mean in disciplinary action, sorry.
Yes, question 3.
Yes, disciplinary action, question 3.
Right. So, I mean,
Right.
technically speaking, was he incorrect to say that he had, to say no in answer to, has any disciplinary action been taken against you by any medical authority?
Well, my submission was that it was a play on words, because at one point he was speaking about the penalties. So if you look at back at 1004,
Mhm.
it says the following penalties were imposed.
It says, sorry?
If it says final disciplinary action, it says the following penalties were imposed.
Well, I'm looking at page 1004. I don't see penalty.
1004.
Yes.
If you go where it says final disciplinary action,
Yes.
if you look in the box,
Pursuant to the final
specifically
order.
the following penalties were imposed. So what I was trying to get out in relation to what the appellant was saying is that, well, I didn't have any penalties imposed at that time. They weren't imposed until February. But the issue is whether or not there was any disciplinary action pending. And so it would have been open for him to say, well, no penalties. Okay, fine. The penalties haven't been imposed.
I see.
But
But
the
there had
action
still been
is
a
pending.
disciplinary action taken against him.
Right, the action was pending.
Yes. Well, the action was in progress.
Well, the action was in progress, yes. So that is why we say he was not being honest. He was being a little bit strategic in the way that he was answering the question.
But I mean, you would argue that he's wrong. He's technically wrong, because disciplinary action would be the proceedings on your argument.
Right.
And those proceedings were well underway. The
Yes.
fact that there had not been a final disposition is neither here nor there. There's disciplinary action that was in place that had that had already started by the 28th of November 2018.
Yes, most definitely.
So his answer of no is untruthful.
Yes, most definitely. And I'm sorry if that didn't come across yesterday, but that's exactly what I was trying to get out of it.
I see.
But he continued to say that it didn't happen until February, but that's the penalty.
And even if he could meet your response, you would argue that that would clearly call for some further explanation. So even if he is able to respond in saying, well, wait a minute, no, you've got this all wrong. That disciplinary action, I can't envisage right now how he might respond to that. But either way, it would be so close to the borderline that this is a response that really should have been further explained with an appendix on, whatever it's about.
Most definitely, which is what the form provides for. It provides for that. And like I say, it didn't have to be the 1,000 pages that he refers to. Just could have been a simple explanation, FYI, this is pending. But yet he just chose to take no.
So just while we're on the application form, that would be incredibly helpful to me to just go through each question as to whether it's true or not true. That would help me greatly. So this one, you would say that he was absent. So question number 3, you would say that was just simply untrue.
That was untrue. Now, in relation to question number...
Yeah, no, please go on. Question number 4.
No, sorry, I thought you was going to ask me about question number 4. Yes?
I am, yes. Question
okay.
number 4, yes.
Right, so in relation to question number 4, now, he the appellant in cross-examination, he sort of did a play on words as it relates to Medicare and Medicaid. Now, he tried to explain that the privileges in relation to Medicare and Medicaid were insurance related. I believe that that's what he was trying to get across to the court. But if I take the court to page, just trying to find the letter, I think it's 16. Page 792.
Okay. One minute, please.
Okay.
All right, you said page 192?
792.
792.
Yes.
Yes.
Right. So he, in his course examination, spoke about Medicare and Medicaid. He said that they were not health facilities. I'll have to go back to question number 4 after we finish this to see which 2 words it mentions. It's a hospital or healthcare facility, I believe. So he indicated that those were insurance related. But what I would say is at 792, it specifically indicates.
Sorry, I thought he had said that these, in relation to Medicare, that this, these are. Oh yes, he's making the distinction between a facility and insurance.
Yes, he was trying to make a distinction between facility and insurance and a hospital. But the idea being, I mean, again, it's something that he would or should explain, because at the end of the day, Medicare and Medicare patients are seen in healthcare facilities, they're seen in hospitals. And his argument is that, well, you know, we can't use these privileges to cover this because it specifically relates to a hospital or healthcare facility. But again, if he was giving a fulsome answer, he would have provided the information to say, yes, I've had privileges revoked.
So let's start.
Or I've had privileges revoked, but let me explain what it is.
Okay, let's just start using the same format. What do you say to question 4? Did he answer it? Technically, was he truthful or not?
Sorry, I lost the page for a minute.
I'm going to draw a distinction between a full answer and a truthful answer. So just starting with the truthful part. What was he truthful?
So he indicates that it wasn't in a hospital
accurate
facility.
Sorry?
So he's trying to be strategic and accurate. So he's trying to say the question only relates to a hospital or healthcare facility. Okay, fine. So his answer was, well, I answered it in the truthful way because it only asks about hospitals and health.
Strictly speaking, it's accurate.
Strictly speaking. But what we would say— You would
accept that strictly speaking, it's accurate.
If we're only talking about a hospital or other healthcare facility by the wording that he's used,
mm-hmm.
But our argument is that Medicaid and Medicare are privileges that are used in hospitals and healthcare facilities.
So it's misleading.
So
again, if I were to almost create 2 columns where a response can be strictly speaking accurate, but also misleading.
Yes.
Is that the category that you would put question 4 in?
Yes, it's very misleading because the argument that we can make is that by revocation of those privileges, well, you can't have those privileges in the hospital as it relates to Medicaid and in the healthcare center as it relates to Medicaid.
Anything else you want to say on question 4?
Sorry, if I can just go back to my notes very quickly, crave your indulgence.
I appreciate I've taken you out of the format of your submissions, but it does help me greatly to just go through these questions, and then I can understand the context of your arguments.
Understood, my lady. Right, well, I think I already made this point in terms of how he would have completed question 4 because that was misleading. But again, he had indicated that he had experience, 30 years experience, had filled out hundreds of application forms. So he should have known that he should have answered that question differently, we would say. Oh, the other thing that he had indicated was that he didn't think that it was relevant to the application to say that these privileges was revoked because he was considering applying for a waiver.
Yes.
And I understand that that waiver means that, well, I would be able to treat the Medicare and Medicaid patients, so it would negate the need to answer yes. So technically, well, not even technically, he knew that the answer should have been yes. But he's saying, well, I knew I was gonna get this waiver, so I didn't have to answer yes because I'd be able to do it.
Was pending. The waiver could have been refused.
Exactly. And he didn't even get it in the end. He didn't even end up getting the waiver.
Is this the portion where you put to him that he had withdrawn his application?
Yes, but he indicated that he had not. He indicated he had not withdrawn it, but that's, I would say that's
the waiver was denied.
Here or there. At the end of the day, he suggested or he indicated that putting yes on that question would have been a waste of time because he was going to get a waiver.
Is that analogous to someone saying they haven't been convicted of an offense because they're in the process of appealing?
Well, yes, but you're still convicted. You're still convicted of the offense. So I think he recognized when he said that he should have answered yes. But he's saying, well, I don't have to because I'm going to get a waiver, which you don't even know if you're going to get. So his privileges at that time, we would say, had been, well, in fact, they were revoked. It says, have your privileges been denied, revoked, or restricted? They were revoked. Right.
Yes.
Right. And the other thing in relation to both questions, and I believe I said he strategically omitted those facts. And he indicated he had asked Dr. Baisden for assistance, but just to make the point clear, we have nothing from Dr. Baisden to suggest that this occurred. And it's quite interesting as, the future employer, they haven't provided any information or evidence. So that's, I think.
Any issue with question number 5, his response?
Pled guilty to any offense. I don't have any instructions in relation to that. And I believe that's probably.
So I need not concern myself with question 5.
No, I don't have any instructions in relation to question 5. It's 3 and 4.
Okay. And despite the misunderstanding, as explained by Dr. Qamar, question 8 is not an issue either.
No.
Okay.
It was actually in Dr. Peekbo's evidence, but basically the two forms, and I suggested it to Dr. Qamar, it's really that there was a difference in the application fee. It was just an error on the first form. And it could be that when he went to fill out the second form, he decided to tick no, but it was a matter of the fee. You can vaguely see it, but in Dr. Peekbo's statement, she does indicate that there was an issue with the fact that the fee was not listed correctly in the first application.
Mhm. Okay.
Okay, so I'm just trying to go back to the questions in my submissions.
I'm
So
sorry
I'm
to
gonna
throw you off, but that was very helpful.
Right, I think this is at the point where my learned friend talks about proven facts. I think I should go back, my lady, so I can get back
Well,
on
you
track.
provided, I saw an appendix on
Yes.
proven facts about the appellant.
Yes, and I know it was belaboring, but I took him through each one.
Yes.
There was a reason why I did that. And it's based on the submission that my learned friend made with respect to one of the cases. But I'm just going to take the court through Lane, Akinley, and Oompa, I believe it is. So,
Are you taking me to the authorities now?
yes,
Okay. That's in your bundle?
it is, but I think it might be easier if I just go from the skeleton.
Okay. Can I pack away this hearing bundle? For now.
For now, yes, for now. Okay. Right, so at paragraph 15 of my submissions, I speak about the case of Lane. I see I spelled Grenada wrong. Don't know how I did that, but at paragraph 15, and I think it might be easy if I just read 15.
Mm-hmm.
Okay. As to the policy for requiring that practicing members of certain professions be of good character, the advice of Lady Arden, with whom Lord Wilson agreed, and Lord Sumpton, and Lady Black concurred, was general in approach. And what Lady Arden said, this is paragraph 36, for understandable reasons, a wide range of professions, and not just the legal profession, have good character and competence conditions for entry into the profession. Those professions include those in which members of the public may place great trust, such as the medical and legal professions. And this is why I made the analogy earlier, my lady, about the legal profession and medical profession being of a higher standard.
Mm-hmm.
Members of those professions, once admitted, have to observe high standards of behavior in both their private and professional lives. They may face disciplinary charges if they fail to do so. The content of a good character condition may vary according to the profession. The person or body which has to be satisfied about conditions of entry may be given powers to investigate or obtain evidence, or limits may be placed on the type of conduct to be examined, and so on. In the context of admission to the Bar of Grenada, satisfaction of the entry conditions is a matter not for the Bar Council, but for the Supreme Court. It is for the Supreme Court to determine the procedure. There are no limits placed on the way the Supreme Court fulfills its rule, and no specific powers are given to it for that purpose. And by implication, it is authorized to determine whether the entry conditions are met in accordance with its practice and the limits of the judicial function. The good character condition must clearly refer to good character appropriate for being an attorney at law in Grenada. It must clearly be satisfied at the date of the Supreme Court decision, rather than an historical basis. And then the board went on to observe the good character condition as two facets, and the candidate's attributes and the risk of damage to public confidence in the profession. And I'm going to move on to the public confidence in the profession in a minute.
Mhm.
So the actions of the candidate at any stage in his career may be relevant to the attributes facet of good character, but the process of considering whether candidate is of good character is evaluative, and both facets of the evaluation are objective. Now, my lady, I would move on to Lord Sumpton, and you can advise me if you wish for me to read through, because I did cite a lot of the case, but I have no problem taking the court through it.
I mean, I'm obviously going to reserve, I'm going to read through all of this quite thoroughly.
Okay.
So if there are some high points that you want to take me through, by all means do so, but there's no need to engage in any laborious
Okay.
of reading passages.
Right,
we
so
can read again.
Okay, my lady, so well, paragraph 21, there I basically outline the qualifications of the committee members,
Mhm.
and just go on to say that, you know, these are properly qualified persons in their specific field, and they're all able to apply their professional judgment competently to find that the appellant was not a duly eligible applicant. So I cite all of that, and that's just the conclusion at paragraph 21. And then I'll move on to Akinley.
Mhm.
So we're at paragraph 23 in the skeleton.
Yes.
I don't believe I need to read the facts for your ladyship. I'll go straight to,
Akinleye, and I have to pronounce it that way because he's Nigerian.
apologies, Akinley. Akinley. Thank you.
Yes.
I'll actually take you to paragraph 25. I won't bother read the factual matrix, because this was the main issue here. So it was an issue about good character, and there were a number of hearings. So I'll skip to the second sentence in paragraph 25.
Mhm.
In the Court of Appeal, the appellant argued he was concerned that the Medical Act made no precise reference to whether somebody was of good character and what it meant.
Mhm.
However, Lord Justice Brooke found that there is no point in that. It is a matter for the judgment of a professional body. Parliament has sanctioned its disciplinary power to refuse to register somebody who was not of good character, to form its own judgment as to what good character means.
That answers directly the question I was asking earlier about the one profession imposing its views as to what good character is on another profession.
Right.
And the medical profession would be best suited to know and
Analyze
understand
what is
and analyze what
What is
good, what's
appropriate
meant
for the
by good
medical
character in the context of the medical profession.
Yes, my lady.
So this would obviously lend to your submission that the board's decision has to be careful regard
Carefully
should be
considered.
given to the board's decision.
Yes.
And the court should not be hasty in setting
disregarding that
aside.
judgment.
Yeah,
Sorry.
in setting that aside.
Right. Yes.
Mhm.
So at paragraph 27, and I say the appellant attempts to distinguish Akinleye
Mhm.
on the basis that it was a judicial review hearing where the issues outlined are based on proven facts. And this is where we get into the proven facts aspect. So I'll just continue on.
Mhm.
He maintains that the allegations made against him have never been admitted or proven. And nevertheless, we say his understanding of the allegations at the heart of this case are misconceived. And it's always been and continues to be the position of Bermuda Medical Council that there are serious concerns with the misleading manner in which the appellant approached his application for registration and during the period that it was pending. Now, I want to move on to, it's not necessarily my skeleton, it's a point that I want to make. Now, in relation to the proven facts, the appellant submitted that the court should adopt the UK General Medical Council good character test.
Mm.
And at paragraph 35 to 37 of my learned friend's submissions, he argues that the court must decide itself whether unproven allegations should not play any part as they are not proven facts. And he suggests that the allegations should not be on the table as they are entirely baseless. Right, you see it underlined at 36 of his submissions.
Yes, I see it.
Right. So as I was indicating, I took the appellant through the appendix, through all of the items that we say are proven facts,
Mhm.
to satisfy the test that my learned friend himself raises. So the appellant agreed with a number of them. And we would say we satisfied that aspect of the test that he's raised in terms of proven facts. And in terms of suggesting that the allegations that are on the table are entirely baseless. I believe I addressed this with the appellant, but again, I'll just clarify. The letter that my learned friend had pointed to us to at page 384 of the bundle. Sorry, my lady, I know I told you that you can put it aside, but I can just tell you what's at page 384.
I mean, I can pull it out if you like.
Right. But it's basically, it's the letter that was to his counsel, the appellant's counsel, which says that probable cause had not been found. And I made the point that that was just in relation to a particular case. It doesn't apply to everything. That one particular case, probable cause was not found. And that's just in response to a submission that I believe was made.
Which case was that? The probable cause panel that they were concerned with that? Was that in respect to the key time claims?
This is the one. Decent. Any disciplinary case for which problem?
My lady, I hesitate to intervene. I can assist the court with that question if required. If not, I'll wait.
Let me hear Mrs. Stevens.
Yes.
My lady, the finding of the probable cause panel related to the allegations of Medicare and Medicaid fraud.
Thank you. Yes, thank you. Thank you very much. Yes.
Right. But I can say that the relevant case that's cited in the BMC judgment, well, both were cited. I believe I took the applicant, and I believe I took the court to the fact that Dr. Ross does specifically take into account the fact that the probable cause was not found in relation to that case. I can take the court to it. It's at page 710. It's just outlining the judgment so that it's clear. Just so that it's clear that the proper value was given to the fact that no probable cause was found. And it's at paragraph 44. So that was taken into account.
Okay.
Okay, and then you'll see at 48, at the bottom, at the last paragraph, you'll see administrative complaint underlined.
Mm-hmm.
Right, that is referring to the case at the heart of it, which you'll see 215-20338 at the top of the next page, 711. So this is just to make the point that the probable cause, it's two different numbers, it's two different cases.
Mhm.
2015 one still stand, disciplinary action.
Okay. Yep.
Okay, sorry. Right. I also want to briefly address copay. I did ask the appellant yesterday about copay, and he played it down and indicated, you know, it was almost an honorable thing to do because people can use the $13.50 he put forth to catch taxis, etc. But I wanted to take the court to page 684.
Mm-hmm.
And this is Dr. Ross's statement, and this is a Department of Justice release. Now, if we go to the third paragraph on this page,
Yes.
I'll read that paragraph. The government also alleged that to help facilitate this false billing scheme, the Qamar and ICE routinely and indiscriminately waived the 20% Medicare copayment irrespective of the patient's financial need. Medicare copayments assure that patients have an incentive to be smart healthcare consumers and avoid unnecessary procedures. By waiving the required copayments indiscriminately, the Qamar and ICE induced patients to agree to unnecessary and invasive procedures and other services. Qamar and ICE illegal conduct made Qamar the highest paid Medicare cardiologist in the country in 2012 and 2013. Patient safety is of paramount importance, says U.S. Attorney A. Lee Bentley from Middle District of Florida. When a doctor performs medically unnecessary and invasive procedures on Medicare patients, federal health care programs are defrauded, and more importantly, patients' lives and well-being are recklessly put at risk. And this case shows our office's steadfast commitment to holding medical providers personally responsible for their actions.
So this was the press statement given out by the DOJ,
Yes.
Department of Justice.
Department of Justice, yes. So, well, Dr. Ross at paragraph 57 outlines.
And this is what the appellant would respond in saying, well, wait a minute, this is all unproved, unsubstantiated, and he's entered into a settlement agreement where he certainly has not accepted any of those allegations to be proven.
Right. I'm grateful, my lady, but I was trying to cite that passage, not so much for whether he did or did not, just for the basic general principle that it's not the quote unquote honorable thing to do, as he suggested yesterday.
In the opinion of the DOJ.
Well, in the opinion of the DOJ, who would have the authority to provide that opinion, I would say.
How do they have that authority?
As a Department of Justice who pursues matters such as this, I would say that they would have the authority to provide the information.
That would be like if we give it a local context, that would be like the DPP making a statement about a case that he would have otherwise prosecuted. Is that not analogous?
Sorry, if I can, I just need to follow it.
I'm just trying to ascertain how fair is it for me to attach weight to what the DOJ has stated in a media statement in the context of what's a proven fact and what's not a proven fact?
And is your ladyship speaking in terms of whether or not you should accept that Dr. Qamar actually did
I mean,
this?
what value do you ask for me to attach to a media statement made by the DOJ in regards to a settlement agreement where the allegations are not accepted by Dr. Qamar?
Right. What I'm trying to say by this statement, let's for a minute forget the actual allegations. What I'm saying is that yesterday he suggested that it was a good thing that he was doing. And if you look at the general statement of the DOJ, they're saying that it's not, regardless if it was him or someone else. I'm just trying to put before the court.
Why should I accept what they're saying? Dr. Qamar has explained himself, saying that he's proud of what he's done. He's spared them $13.50 or whatever the figure was. And not only that, but that the Medicaid or Medicare system allows for him to do that.
Well, my lady, I would say that based on, I can simply put that based on what is here, it's not something that's favored, whether it's Dr. Qamar or anyone.
I mean, is there any evidence as to whether or not that's something that he was able to lawfully do? Because he put it, he said it in his oral evidence that it's something he can do. He exercised a discretion that was within his power to exercise. That's what he said on the cross-examination.
Unfortunately,
that's no evidence in front of me. Is it uncontroverted? I mean, how am I to treat that?
Well, my understanding, and again, I'm not an expert in U.S. law.
I'm just saying what the evidence is. The evidence in front of me.
Oh,
so the only evidence that would controvert that would be, I suppose, what's stated by the DOJ.
Yes, what's stated by the DOJ. I think so. Your ladyship is saying there's no evidence before you to suggest that, the U.S. law does not provide.
He suggested in his evidence that he was lawfully entitled to do that. That was the effect of what he was saying.
Well, what we have here is what the DOJ has stated. And the either being, I mean, the DOJ are the, how should I put it? The upholders of the law. They would be well-versed in what the provisions would be. But that's probably the highest that I can put it.
Because I mean, all they're talking about is describing what were the components of the lawsuit that they would have pursued, but for the settlement agreement. So you're asking for me to, or it seems that you're inviting this court to now somehow find these remarks to be proven facts.
Well, the remark that I'm trying to bring the court's attention to is where it starts at when a doctor performs. So the either being, I'm simply trying to put forth that yesterday, Dr. Qamar indicated that it was an honorable thing that he did in terms of waiving the copay. So
and if the type of copay he did was waived minimal. He's
right,
like
and he's
$13 type.
Right, and he says it's minimal.
Then he went further. He also said not only is it minimal, but there's no way that a waiver of that type of that level, that so small, could induce someone to have invasive or more serious type medical procedures done. That would not apply to him, was his evidence. He explained that, there's absolutely no way you can say, says Dr. Qamar, that a waiver of $13.50 is going to convince somebody to now undergo, I don't know, triple bypass heart surgery or something of the like.
Well, sorry. What I would say is that the general statement, disregarding what's above that about what Dr. Kumar did or what ICE did, the general statement that's provided by the DOJ, which starts with when a doctor, I'm simply saying that that generalized statement, whether Dr. Kumar says it's minimal or wouldn't encourage people, that generalized statement seems to suggest that it would. Not saying that he did it, not saying that you have to accept what's listed above that, simply saying that he's now trying to say that it's an honorable thing to do, and this seems to suggest that it's not. That's the highest that I'm trying to put it before the court. I'm not suggesting that the court
Well, then,
accept.
but then why does the system allow for it to be done?
Well, I accept that Dr. Kumar's evidence is that, but I would say that it doesn't say here that it cannot be done, but based on the generalized statement, it would seem that it's not something that they believe should be done based on that generalized.
I mean, it would leave me certainly with an impression, or it seems that it gives way to an inference that it depends on what kinds of co-payments you are waiving. Because the word, by waiving the required co-payments indiscriminately, I mean, is there a difference between indiscriminate waivers of co-payment or different levels of, I mean, I just don't know, and I cannot speculate. I mean,
Right.
this is not even, this is an ancillary part of your case in any event.
It is, my lady. It is, my lady.
How much?
I agree.
Yeah, how
No,
much
I agree.
do you really have to?
No, I agree. I wouldn't belabor the point. I was simply trying to just make that analogy because I know that he was trying to put before the court that it was an honorable thing to do. So I just wanted to bring that analogy to the court. But I accept.
Point for you to make.
I accept that it's not necessarily. It's just an ancillary aspect. Okay. So I'll move on, my lady.
My lady, could I possibly beg the court's indulgence for a short comfort break? I appreciate it.
I have to confess, I didn't appreciate the time, and I would have liked to have even done it a little earlier, but definitely I would think no is a good time. Ms. Dilfrancois, is a good point for you?
Yes, I'm good. Yes.
And shall we resume at 11:30? That gives us a 15-minute break.
Okay.
Okay.
Thank you.
Thank you. Okay, can everyone hear me?
Yes,
Not
my
yet?
Yes, my lady.
Okay, let me just check with Miss Aswood. Miss Aswood, the Court Smart, which is still the official record, by the way, the Court Smart is operating and running?
Yes,
Okay, thank you.
you're welcome.
Yes, all right, on my clock it is 11:31, let's resume.
Thank you, my lady. If I can take the court to paragraph 47 of my submissions.
Yes, I'm going to just put away this hearing bundle for a moment. Okay. But I have it to hand if you want to make more references.
I'm grateful. So at paragraph 47, your ladyship here.
Yes.
So at paragraph 47, I have the appellant cites the UK's Council for Healthcare Regulatory Excellence 2008 paper as the correct standard for assessing good character. However, even if this court were to be guided by this approach, two of the criteria cited are whether the appellant in question had acted, number one, in such a way that puts at risk the health, safety, or well-being of a patient, or had behaved in a dishonest manner. And that's in his authorities at tab 8. So I'll now go down to paragraph 50. Now I want to make sure that I pronounce this properly. This is the Fumpa case.
Well, I'm not here to correct you.
So, Fumpa, in this case, the appellant appealed to the High Courts of Justice against a decision of the Medical Practitioners Tribunal to impose the sanction of erasure from the register for dishonesty was upheld. And I'll read the facts. So at paragraph 51, in that case, Dr. Fumpa qualified as a doctor in Holland in 1991 for a period of 18 months or so in the mid-1990s, and he registered with the General Medical Council in the UK. In May 2003, an allegation arose in the Netherlands in which Dr. Fumpa was accused of sexually touching two female patients under the age of 16 whilst they were sleeping. Dr. Fumpa was prosecuted and after exercising his right of appeal was convicted of a criminal offense for one of the patients, and he was therefore sentenced to imprisonment for 6 months, suspended for 2 years. And that was in October 2005. In October 2004, he made an application to join the GMC Specialist Register in the UK. And when completing the form, he answered no to, among other things, the question as to whether there were any proceedings pending against him in his home country. He responded no to the questions and was registered practicing until he resigned in December 2015 due to an anonymous email disclosing the fact that he had a conviction. Now, at the time of Dr. Fumpa's dishonest declaration, the GMC's good medical practice did not articulate an explicit duty to report criminal convictions to the GMC. However, it was accepted by Dr. Fumpa that it was wrong of him as a UK doctor regulated by the GMC to hide the conviction, notwithstanding the lack of specific, explicitly stated duty to report. And I have her see paragraph 77, but it should be paragraph 30.
Paragraph 30?
Yes, that should be 30. Now, the court found at paragraph 82 of the judgment, and instead of taking you to it, I'll just read it from my submissions in skeleton. Are you ready, my lady?
No, I'm sorry. I was just rereading what Dr. You have it spelled Fupma, but I think it's Fumpa. But either way, I was just reading. He's accepted that it was wrong of him as a UK doctor regulated by the GMC to hide the conviction, notwithstanding the lack of a specific, explicitly stated duty to report. Okay. All right. And you're going to take me to the decision? Or
right. Well, what I said is that I can just read it from what I have here.
Yes.
Yeah. Okay. So at paragraph 82 of the judgment, the failure to disclose, even if there had never been a specialist registration application form submitted, was ongoing throughout that period, as Dr. Fumpa plainly, it seems to me, appreciated throughout. In those circumstances, in my judgment, there is nothing whatever in the suggestion that the tribunal erred in finding that the dishonesty was persistent.
Mm-hmm.
And so we say at paragraph 56, based on the reasoning in Fumpa, and we admit that it's a different set of facts, but it's our submission that the appellant's failure to disclose the fact that disciplinary proceedings were pending against him and then were actually imposed whilst his application for registration was still pending amounts to dishonest behavior. And so we say the court can rely on, and I believe I may have already addressed this earlier, that you can rely on the professional judgment of the committee to say that he acted dishonestly. But this basically goes back to my point that you can't just rely on the fact, well, it did not specifically say this or it did not specifically say that. This case indicates that, well, you have an ongoing duty to provide that information nonetheless.
Something in the first instance stage of the application process, can it be said that there's a burden on Dr. Qamar to establish that he is of good character and that he is suited with the qualifications necessary and all of the other criteria? Is there any burden that would be on him to prove to the council that he is all of those things, as opposed to the council disproving?
Well, I would say the council is not there to disprove it. It's for him
to establish and to show.
Yes, it's for him to provide the information. The council is there to assess it. They wouldn't automatically go toward, oh, well, we're going to just say he's not. It's the other way around.
And so really what we're looking at is Dr. Qamar's failure to establish before the medical council his good character.
Yes. Yes.
The onus was on him to establish it as part of the application process.
It would have been on him. It's for him to provide the information. It's his application.
Mm.
So yes, that is our submission.
Mm.
So I'm going to move on to the reputation of the medical profession.
Sorry, one moment. Just while I'm considering whether or not the subject of burden properly arises in this kind of a case. This is an appeal, and I will obviously have to resolve in my mind really what the role of the court is in its appellate jurisdiction in terms of, I think Mr. Stevens made a distinction in his opening speech as to an appeal de novo and then a rehearing. And I understood Mr. Stevens to be saying that this is not an appeal de novo. So do I need to concern myself at all with the question of burden or standard of proof, or am I merely looking at this through the eyes of an appellate court in terms of the decision that was made and the evidence that was, well, I'm saying the evidence, well, it is evidence, the evidence that was before the medical council?
I think that you would, because it's still relevant to the issue at hand. It would have been for him to establish, the burden is on him to establish his good character. So I would submit that the court wouldn't just look at it in a vacuum. They'd have to look at that aspect as well. So I would hesitate to say that that's not something that the court will consider. You just look at it in a appellate.
And then if there's a burden, what's the threshold? What's the standard of proof? Is it the ordinary civil standard of proof? Does one talk about the question of burden and standard of proof in cases like this?
I can't say that I've seen any burden of proof.
I mean, there seems to be no mention whatsoever of that process. That analysis would obviously be reserved for a court sitting in its first instance, its jurisdiction of first, its original jurisdiction, to assess whether or not the applicant, the plaintiff, the party initiating the proceedings has satisfied and proven whatever is being asserted. But in this case, where I find myself having to determine exactly what the role of the court is, somewhere between a rehearing, but still not being quite a hearing de novo. I see that Mr. Stevens has taken off his mute button, so I assume he wants to weigh in.
Well, I didn't want to cut across my learned friend submissions. I can address this point in my closing if that's more convenient. I was only saying it's obviously it's the appellant's case that in the absence of a accepted standard for assessing good character on the registration of medical professionals in Bermuda, that one should look to the equivalent test that is used in equivalent jurisdictions by equivalent bodies. And that's why we say that the test adopted by the General Medical Council at a time when good character was part of the assessment that the General Medical Council would make when deciding whether to register professionals is a very useful guide for the court in terms of the approach that it should take to the question of what good character means in the context of registering medical professionals. As for the question of burden, I think it's a distinction between the burden at the time that he made the application and the burden now, because obviously the court, what we say is that the court is involved in a rehearing, it's hearing fresh evidence, and it needs to decide for itself whether or not the appellant is a good character. We accept that the burden is on the appellant. I don't think there's any question about that, and that's why the appellant has come to this court, has presented fresh evidence, has instructed counsel, and we are seeking to make his case that he fits the criteria of being a duly eligible applicant under the Act. And we feel that in the final analysis that we will have discharged that burden.
Mm-hmm. Okay, thank you very much.
Okay.
Yes,
right.
Mr.
I'm grateful. So I believe that approaches the court's concern in that regard. Did you have any further questions? For me? No, I was asking, did you have any further questions for me in that regard?
No, thank you. I think that was actually very helpful from Mrs. Stevens.
Right. So I'm going to move on to paragraph 57.
Okay.
Now, I will pronounce this one, Anduka.
Mm-hmm.
So Anduka and the General Medical Council. Now, in this case, the Medical Practitioners Tribunal found that the appellant's fitness to practice was impaired by misconduct when he failed to declare on 3 separate job applications that he was the subject of an ongoing fitness to practice investigation. It was their position that the appellant had departed from expected standards of conduct and behavior, and as a result, the tribunal imposed a sanction of 4-month suspension. Now, the appellant appealed the decision on a number of grounds, stating that the sanction imposed was manifestly excessive and that he had been subjected to malicious harassment and victimization by the GMC. Lang J. upheld the decision of the tribunal and dismissed the appellant's appeal on all grounds. At paragraph 9 of the judgment, he cited the case of Meadow v. General Medical Council, which found that weight must be given to the fact that the body from whom the appeal lies is a specialist tribunal whose understanding of what the medical profession expects of its members in matters of medical practice deserve respect. As a result, Lang J. held that the panel is centrally concerned with the reputation or standing of the profession. In paragraph 69 of the decision, Lang J. quoted the tribunal's comments regarding the decision on impairment. And here it stated, the tribunal went on to consider whether your fitness to practice currently impaired as a result of your misconduct. In making its decision, the tribunal took into account the public interest and bore in mind that the purpose of fitness to practice proceedings is not to punish a doctor for past wrongdoing, but to maintain proper standard in the profession and protect the public. And at paragraph 35, however, the tribunal has a duty to maintain the reputation of the profession and to declare and uphold proper standard of conduct and behavior. It is of the view that doctors occupy a position of privilege and trust in society, and members of the public are entitled to place complete reliance upon doctors to be honest and to act at all times with absolute integrity. Members of the public rightly expect that any doctor filling in forms would do so honestly. And so we say that whilst misconduct is a statutory criteria for fitness to practice in the UK, pursuant to Section 95 of their Medical Act 1983, it's our submission that you can gain useful guidance from this case, my lady. So we say that members of the public would expect that the appellant, a medical professional with over 30 years experience, that he would act with honesty and integrity. And the committee has vested interest in ensuring that this standard is maintained. And we will submit to the court that on that basis, the appellant is not of good character. Now there's one more thing that I want to take the court to, and this is the appellant's reason for wishing to work in Bermuda. That's not at my submissions. I know it was a question raised yesterday when I was cross-examining the appellant and what the purpose of the questions were. So it was in relation to salary. I know my learned friend had forwarded the contractual agreement this morning. I didn't get a chance to look at it, but I still address the issues regardless.
I'm just going to put it up on my screen because I saw that it was sent on to me. So 1 minute.
Right. Don't get it.
So compensation and payment looks to be at paragraph 3. If you want to address me on it. I imagine that Mr. Stevens will likely raise it.
Right. So this is what I would say about it. And I'll just read what I have here. So the appellant appears to suggest that he and Mr. Gear will likely, quote unquote, rescue Bermuda.
Sorry, where are you reading from?
No, I'm reading from something that I wrote after my submissions based on what.
I see. So I can just listen to you?
Yes, you can just listen to me. Mm-hmm. So the appellant appears to suggest that he and Mr. Gear will likely, quote unquote, rescue Bermuda from its inadequate cardiovascular care resources. But one must question how they have come to this conclusion before researching the situation thoroughly and discussing in detail with local specialists and performing a proper gap analysis of the health system in this area. And this begs the question as to whether he's being entirely genuine as to his intentions here in Bermuda. Dr. Doherty's evidence, which has not been challenged, outlined whether there was a need for a proposed facility and the profit that the appellant would make. Now, initially in cross-examination, the appellant indicated that he would be disadvantaged in taking the pay cut by coming to Bermuda, but he later attempted to clarify the position, and it's likely that this clarification was warranted, as this statement would be contrary to what he says is the sole reason for wanting to open a practice in Bermuda, i.e., that he wanted to help create a world-class program. But the appellant advised that he currently works 5 days a week from 8 a.m. to midnight. And he admitted that at the age of 56, he wants the younger partners to take the night calls. He agrees that when he first comes to Bermuda, it's the case that he would only be working 3 days a month, but he says that's until the facility is fully operational but that takes a while, so it could be like a year. And based on his comment regarding his desire to no longer work night calls, it's unlikely that even once that facility is fully functional, that he'll be working the 8 to midnight shift. And according to Dr. Doherty, the appellant would still stand to gain a tremendous profit even while working severely reduced hours. So although the appellant states that he would be disadvantaged as his salary would be less, he would still stand to make a considerable salary for doing substantially less work.
How does this relate to good character?
Because I'm simply trying to say that it goes to the heart as to how he would, whether or not he would benefit from providing inaccurate information. So it's just sort of an ancillary matter. The fact that he completed the form incorrectly can go to the heart of, well, this is because he had other intentions here in Bermuda. So I'm just sort of
obviously he's if he's applying to register as a practicing physician in Bermuda, there's benefit to be gained from it because he's making the application. Why am I being invited to now get into granular details about what he would make here, or what financial profit it would be for him and so forth? Why does any of that matter? He clearly wanted to be registered and he clearly did it voluntarily. So if he were refused, that would be disadvantaged, that would be of disadvantage to him. And if he were to be accepted, then that would be to his benefit. Why do we have to go beyond that?
Well, I agree with your ladyship. It was a benefit, which is why he actually made the application.
Yes.
So what I'm saying is, in making the application, he did not provide fulsome answers, and he was dishonest on the application
because he wanted to be registered, is what your case is.
Because he wanted to be registered.
And if he had given that information, he would have been declined, is what your case surely must be.
If he had provided,
in his mind, had he provided that information,
yes,
he would likely have been refused for registration. Yes. So his motive for being dishonest was to get his application approved.
Yes. Yes.
Why do we need to go beyond whatever his salary package would have been and what he would have made and all of that detail? Is that not?
Well, I agree. It's an ancillary matter, but it was just to put before the court.
Just giving me more work to look through.
I'm grateful, my lady. No, I accept that. It's just to put before the court because this was something that was raised. He said he would be disadvantaged by coming here.
I mean, now we've got this contract and you're inviting me to look to see what his compensation would have been. That's all unnecessary. I mean, how far are we going to go with this?
No, we don't have to go that far. We don't have to go that far. I was simply pointing out the fact that he said, he wanted to do a world-class facility, and
he wanted to get registered in Bermuda. He had his reasons.
Yes,
and he wanted to be approved. What we can certainly infer irresistibly is that he wanted this application to be approved.
Yes,
he submitted it, and his motive for filling out anything that he filled was to get a registration number.
I'm grateful. No, I agree. I definitely take the court's point on that point.
Okay.
On that position. So I think that's the majority of what I wanted to say. I'll just conclude by saying that the appellant argues that this is a matter of procedural fairness, as he's not in a position to second guess what information the committee would expect him to disclose. However, the committee considers that an honest, ethical, and transparent physician applicant of good character would have proactively disclosed the fact that disciplinary penalties have been imposed upon him in February 2019 because Dr. Ross states the committee believed that he had a continuing duty of honesty since his application for registration was still pending and was still being considered. And I'll also say that additionally, the appellant did not disclose he had been terminated from Medicare and Medicaid, whilst the appellant admits that this was a straightforward, truthful answer, i.e. that he did not have these privileges revoked at a hospital or healthcare facility. And we had discussed this earlier, that it was not a full answer. It was a misleading answer. And finally, it's our respectful submission that the committee was justified in refusing the appellant's registration application. And we ask that this honorable court follow the reasoning set out in Gosh, paragraph 34, that the court must trust and accord the appropriate measure of respect to the professional judgment of the committee, and that the appellant is not of good character, and as such, that the appellant is not of good character such as to merit registration as a medical practitioner in Bermuda.
Okay.
So my lady, those are my submissions, unless I could give any further assistance.
No, thank you very much, Ms. Francois. That was as helpful as Mr. Stevens' submissions were. I'm sure that he will want to follow you now. It's 12 o'clock, and I can tell you I would like for us to finish up and not have to come back this afternoon.
I'm grateful, Mary. You'll be relieved to hear that I'm going to be much shorter in my closing than I was in my opening.
Yes.
Would you like me to? I can proceed now. Is that
yes,
fine?
Please.
So, I mean, the bulk of the principal submissions on the facts and the law of this case were front loaded into my opening, as I'm sure was obvious by the length of time that I took, and that was a deliberate decision on my part, because I believed it was important for the court to have a reasonably thorough grasp on the issues before it heard from the appellant in cross-examination. So I will be much shorter this time. Obviously, I had some things I was going to say in any event, but I also need to respond to some of the matters that were just raised by my learned friend in her closing. I'd like to start by dealing, if I may, with what the appellant regards as a very large red herring in this case, which has been ventilated before the court, which is the issue of whether there is a market or a clinical need for the services that the BMSG wishes the appellant to deliver in Bermuda. Now, this issue was explored in, my lady will have seen in quite a bit of detail in the witness statement of Dr. Doherty in this case. And if I could ask the court, please, just to turn to that witness statement, which is at 491.
Is that Dr. Doherty or Mr. Doherty? Which one is?
That is Dr. Doherty. Dr. Doherty is not a member of the Credentials Committee, to my knowledge, but is one of four cardiologists on the island who obviously has.
Right. Sorry. Who? Just one. Oh, I see. Mr. Gear. I was confusing him with. Sorry.
Yes, that's right. Mr. Gear is on the
prospective employer. Yeah. Okay. So, am I going to look at Dr. Doherty's statement now?
We look at Dr. Doherty's statement, yes, please, which is at 491.
Okay. Second. Yep.
Thank you, lady. Now, it's fair to say that Dr. Doherty has some very strong views on the appellant's application for registration.
Okay.
And his predominant objection on the face of his witness statement is that there is no genuine clinical need for a cardiac catheter lab in Bermuda, and also that the introduction of such a lab would increase healthcare costs on the island, I think is his primary submission.
But before you go any further into that, how relevant is that to the issues before me?
Well,
because I had understood, and you would have heard me intervene into Ms. Francois' submissions on numerous occasions with this point. I am concerned with the issue of good character.
indeed.
So, I mean, to what degree, if I'm going to be going into all of these other extraneous factors, that would appear to me that I'm now dealing with this de novo.
Indeed, my lady, and that's why I described Dr. Doherty's evidence as a red herring for the court, because I think there's as the way that the evidence is played out, there has developed almost a sub issue, which we say is an irrelevant issue, as to whether or not the services that the appellant may or may not provide when he arrives in Bermuda, whether there's a clinical or a market need for them. And all I want to say, and it is consistent with the question you just asked, is that an applicant's registration as a medical practitioner in Bermuda under section of the Act has nothing whatever to do with the question of whether Bermuda in fact needs those services. Whether there's a market need is a commercial decision for market participants.
I find it very difficult to be interested in the point.
Exactly.
I perhaps in reviewing the submissions of Ms. Francois, I may see it differently, but it seems to me that the issue is good character.
Indeed, and that is the appellant's position. So what we are saying, and I think the court may already be there, is that all of the evidence in this case, including from Dr. Doherty, concerning whether or not there is a clinical or market need for the appellant's services, should be completely disregarded.
Sorry, I do want to hear from Ms. Francois on this very narrow point before you continue, please, Mrs. Stevens. Ms. Francois.
Yes, my lady.
Because it's important that I fully understand your position. I have understood your position, once again, I feel I've said this many times now, to be squarely on the issue of good character. We spent much time looking at the law and what it means on good character. That is a criteria on which he failed in his application for registration. That is the very reason why I found myself critical of whatever the compensation package was and so forth. The issue is good character. Why should I be interested in whether or not there's a market for a specialist of a cardiologist, as it's put out in Dr. Doherty's statement? Why is any of that relevant?
Well, the idea being that at the time there was no consultation. It's just to set the picture as to how this unfolded. The application was made. They indicated they needed to set up this facility. There was no consultation. So it's just to give the court an idea of what's required in Bermuda, what they need, what they don't need.
Why do I need to know any of that?
No, and I accept and I understand the court's point with respect to good character, but that's what the purpose of this information was to sort of give an outline of what's required. Because of course, what was put forth in the applicant's affidavit was that Bermuda didn't have, proper facilities, etc. So this was a response to what he was saying. He put forth that.
It's just a long, irrelevant narrative, probably on both sides, to be frank about it. I do not want to be drawn into that kind of distraction and find myself erring on trying to resolve issues which are really completely outside of the issue in dispute, as I see it. I'm looking at whether or not the council erred in determining that Dr. Qamar was not a person of good character.
Yes, I agree.
This was in
response. Yes, this was in response to some of these suggestions.
So it got into a back and forth, and had I micromanaged the matter a little closer, I might have struck all of that type of evidence out.
Right.
Okay. All right.
But we do accept the main issue is good character.
Thank you.
You are correct.
The only issue.
Yeah, is good character. Yes.
Okay.
The only issue is good character.
All right. Yes. Thank you, Mrs. Stevens.
Thank you, my lady. And everything you just said is entirely consistent with my submission. The only substantive issue before you is the issue of character, and all this evidence from Dr. Doherty and anybody else about medical needs should be just disregarded and off the table. But there's a second facet, if I may, to Dr. Doherty's objection to the appellant's registration, and that is more centrally relevant to the questions that we are discussing in this appeal, which is that in his view, the registration of the appellant would in some way tarnish the reputation of the medical community in Bermuda for upholding the highest standards of care and probity. And this is at paragraph 28 and 29 of his written statement. And I just wanted to deal briefly with that, if I may. Could I ask the court to look at paragraph 28 of Dr. Doherty's statement?
Yes.
And that is on 499 of the bundle.
Yes.
The final, if I may ask the court to look, it's about, I would say, sort of 80% of the way down, sentence beginning, it is also concerning.
Yes, I see it. One moment, hold on. I saw it. It also seems strange. Oh, I see it. Yes, it is also concerning. Mm-hmm.
So I'm just going to take the court through that passage and a short passage at the top of paragraph 29, if I may.
Okay.
It's also concerning that Mr. Gear, who's familiar to the court, has been persuaded by Dr. Qamar that there's been a complete vindication of Dr. Qamar's position in relation to the allegations against him, when the cases against Dr. Qamar were settled by him in the millions. I personally remember reading about the public furore raised about Dr. Qamar's alleged legal activities a few years ago, when he was featured regularly in medical news forums such as Medscape and in the press generally. And then over the page, Dr. Qamar was widely reported as earning more than $18 million from Medicare alone, as the nation's highest biller for interventional procedures in 2012. I see that he's now saying that his figures includes billings by doctors working with him, but I recall it being reported in the Herald Tribune that doctors in his facility use separate billing numbers. And then he says, of course, I do not know what the truth is on this. And then if the court could go over to the next page, which is paragraph 33, which is the final word from Dr. Doherty on the issue of whether or not the appellant's registration would damage Bermuda's reputation. He says, I am also gravely concerned, this is in the middle of paragraph 33, my lady, the second sentence. I'm also gravely concerned.
Yes, I see it.
Also gravely concerned that Dr. Qamar is allowed to practice in Bermuda, then we may well be seen as a jurisdiction lacking in probity, with our excellent reputation for high standards of conduct in the practice of medicine called into question. Now, as I've just taken the court, Dr. Doherty admits in his evidence that he has no personal knowledge of whether the allegations that he is quoting from media sources are true. So again, this is another example of somebody connected with the respondent, giving evidence on behalf of the respondent, falling into the trap of concerning itself with, how the admission of, or the registration of Dr. Qamar would be viewed in the court of public opinion, which, as I just took the court to yesterday in the case of Gosh, is not the correct test. And I would just simply ask, the evidence of Dr. Doherty, this is all I'm going to say in relation to the evidence of Dr. Doherty, but in relation to his opinion evidence as to whether or not the appellant should be registered, I would invite the court to completely disregard his evidence. It's bad evidence. And while I would tread very carefully on this point, no doubt the court may consider the specific jurisdictional context in which that evidence is being given and form its own views as to Dr. Doherty's potential motivation for saying what he's saying, given that he's one of only 4 cardiologists currently practicing on the island. I would take my submission no further than that, my lady.
Well, it raises to my mind the question as to, you talk about opinion evidence. I cannot accept opinion evidence that's not expert opinion evidence. And expert opinion evidence has to be independent.
Indeed.
And given with leave of the court.
Indeed. And one has to remember the point I was making. I wanted to address the court on the respondent's evidence. The evidence is there. And the point I've made my submissions in relation to this specific part of Dr. Doherty's evidence. And I was just reminding the court that in viewing his evidence on this point, one should remember that if the appellant is allowed to come and practice in Bermuda, then Dr. Doherty will obviously be a competitor in the market. and the court can form its own view, therefore, on whether or not it should give Dr. Doherty's opinion of.
I mean, he can give evidence of facts, which may be helpful, background facts in relation to the profession. But I mean, in this case, I find it pretty irrelevant, as I've already explained ad nauseum now. So I don't really know how much weight I would attach to any of it, to be frank. But again, I'll have to review it. And
indication. That's all I had to say about that. We were talking about Dr. Doherty's evidence in the context of clinical need. That's been dealt with, and I just wanted to draw that additional facet of his objection to the appellant's registration to the court's attention and make some submissions. Talking of facts, I'll now move on. The second thing I'd like to talk about is this issue of proven facts. The respondent took some time yesterday during the appellant's cross-examination to put to him certain quote-unquote proven facts.
Yes.
And these are the proven facts that are contained in this appendix to the respondent's skeleton. And the respondent's reason for doing this was apparently in response to my case, that this court should only take into account proven facts when assessing his character, not unproven or discredited allegations. But with great respect to the respondent, and the respondent has completely misunderstood the appellant's case on this point. And again, I think this is a very large red herring, because of course what the appellant is talking about when it's talking about proven facts is proven facts of wrongdoing.
Yes.
Not just talking about facts generally.
Yes.
The key point being that anybody can be accused of wrongdoing, but unless those allegations of wrongdoing are in fact proven, we say then on an objective basis, a right-thinking member of society, which we say is the standard that the court should apply in this case, following the guidance of the General Medical Council, would not take unproven allegations into account when assessing good character. And the point is, for the vast bulk, if one reads the appendix to the skeleton, the vast bulk of the appendix, all the respondent is doing is reciting the fact of the allegations that were made. The fact of the allegations, the fact that there was an investigation, and the fact that a settlement was reached. But the point is, the appellant does not dispute those facts. It is a fact that those things happened, but that is not the point. So I
think the most that Ms. Francois could really argue is that the application form did not convey. I think we were looking at particularly questions 3 and 4. It did not. It was very misleading on question 4 and outright untrue on question 3.
Indeed.
In terms of, I don't know if I want to paraphrase it, I'd rather have the language right in front of me. But to the extent that there are any proven facts, I think it's only relevant to those 2 questions on the application form.
I'll just say though that it's important that these proven facts were put to the court on in response to my argument that only proven facts should be taken into consideration. So I think it's important to point out that the proven facts that are set out in this appendix are proven facts as to the allegations and settlements and
yes, I accept that. But let's look at it in the context of the application form, because that's really what this is all about.
Later, I'll be coming on to that very quickly. I just wanted to make the point that if anything, the appendix of the skeleton argument makes my case that the respondent's approach to the appellant's application was heavily coloured by the nature of the allegations that were made, the unproven allegations, and the publicity that those allegations generated. And that's all I wanted to say about that. But I thought it was important to deal with that appendix because I was very firmly of the belief that the respondent is misconstruing the appellant's case on that point.
Well, I mean, none of that really matters to the extent that it impacts questions 3 and 4.
Indeed, my
It's
lady.
difficult for you to, it's difficult for me to engage fully in the point that you're making about the appendix without you tying it to questions 3 and 4.
Okay, my lady. I take your point, and I'm going to come to that specifically to the form in due course. I just have a couple of other submissions to make before if I get there. I think that very quickly the court has already dealt with this, but in terms of the motivation, we're talking of the motivation of the appellant to come to Bermuda. We say that's of very peripheral relevance, if no relevance at all. And I think the court is with us on that. So I just wanted to make that clear. We had provided the court with evidence of the appellant's remuneration, but it strikes me that in view of the conversation we had yesterday, that's why we provided it, but it strikes me that that is no longer really the court's main concern, so I'll move on. I wanted to deal, my lady, if I may, with the question of how much deference the court should give to the original decision, because that was something that was I covered in my opening submissions, but it was also raised again today by the respondent. And the respondent, and the two key paragraphs, and I think the parties are ad idem on this point, is the two key paragraphs, and the paragraphs that the court should look to and apply are paragraphs 33 and 34 of the Gosh case. I pronounced that correctly. And my learned friend took the court back to those paragraphs and read from them. And she read from paragraph 33 and the top part of 34, including a reference to the case of Evans and General Medical Counsel. But I just wanted to reiterate, I mean, that the appellant says that the key section that for our purposes and the court should have regard to is the final paragraph of 34, where the court is making the point, what the court is actually saying is that the approach in Evans is not necessarily the right approach, and it's not the approach that the court is going to take in, it's not the approach that the court took in Gosh. The court in Evans was dealing with a complaint from the Professional Conduct Committee of the General Medical Counsel, and the court in Evidence was making the point that when it comes to professional misconduct matters, which necessarily may involve some element of technicality, the Professional Conduct Committee is in a much better position than the court to form a professional view as to whether or not professional misconduct has taken place. And the court in Gosh, while accepting the ratio of Evans, went on to clarify its position by saying, yes, the board will accord an appropriate measure of respect to the judgment of the committee, whether the practitioner's failings amount to serious professional misconduct. But the key section is that the board will not defer to the committee's judgment more than is warranted by the circumstances. The council conceded, and their lordships accept, that it is open to them to consider all the matters raised by Dr. Gosh in her appeal, decide whether the sanctions of erasure were appropriate and necessary in the public interest or excessive. And in the latter event, either to substitute some other penalty or to remit the case to the committee for reconsideration. So the court in Gosh is actually distinguishing Evans, the approach taken in Evans, which is not a distinction that was, not a point that was raised by my learned friend, and I wanted to make sure that was before the court, is that Evans was one approach. What the court is saying in Gosh is, yes, we accept Evans to a certain extent, but it only goes so far. We are entitled to look at all of the evidence afresh, and we are entitled to substitute our opinion for that of the original decision. And my learned friend also took you, on this same topic, my learned friend also took you to the case of Luby in Newcastle under Lyme. That is at tab 7 of the Respondents' Authorities bundle. Now, we say that Luby can be distinguished from the facts of this case, because the main reason it can be distinguished is because it was not a rehearing. Just bear with me 1 second, my lady. I want to make sure that I've covering all these points correctly. But Luby was an appeal, a straightforward appeal from the housing association's decision to set rents at a reasonable level under the relevant act. So it was involved in appealing as a decision of the UK Housing Authority to increase the rent paid by Mr. Luby pursuant to its discretion under the UK's Housing Act 1957 to set rents for its properties at what it regarded as a reasonable level. And we say the cases of limited assistance on this point, this specific point about whether or not the court, what level of deference the court in this case should give to the respondent's decision, because in Luby, the court was not rehearing the case. There was no fresh evidence before the court. It was purely a question of whether or not the housing association had exercised its discretion appropriately under the Housing Act to set rents in the properties that it had control over at a reasonable level, and whether or not that decision was ultra vires, the Housing Corporation under the Act. It was not a rehearing. So the respondent relies on this case to as authority for the proposition that you should give great deference to the original decision. But the point is that Luby was not a rehearing, and this case is very much a rehearing. So one takes a different approach on a rehearing than one does on a straightforward appeal. And that's all those are our submissions in relation to that case. If I may, my lady, also going back to the case of the Privy Council decision in Lane and the risk of damage to the public confidence in the profession. My learned friend covered this in her submissions. And the one point that I just wanted to reiterate about that case is what the court was saying in Lane was the question of whether or not there would be a risk of damage to the public confidence in the profession is an objective test. It's not a subjective test. So I took my lady to the relevant paragraphs yesterday, which is paragraph 43 of Lady Arden's speech and paragraph 79 of Lord Kerr. It's not a question of the court or the respondent at first instance putting itself into position and thinking, well, oh, if we register this medical practitioner, what is the public going to think, and how is that going to reflect on us? It has to put itself in a position where a right-thinking member of society, armed with all of the facts, would that person on an objective basis view the registration of this particular individual as likely to damage the reputation of the profession? So it's an objective standard, not a subjective one. And we say when one applies an objective standards to the fact of this case, the question of whether or not there would be some risk of damage to the medical profession in Bermuda is not met.
Mrs. Stevens, let me just give you some insight into what I think your real focus should be on.
Okay.
I have so much paper in front of me.
Yeah.
But as I see it, the simple issue is this. This application form, I come right back to it. Does this application form stand as evidence of dishonesty or any lack of integrity which would impugn Dr. Qamar's good character?
Yeah.
There are many issues that have been raised, but I quite frankly see this as very simply down to, does this application form show a willfulness to mislead the council? And in doing so, is that evidence of a shortage or shortfall on good character?
Indeed. Okay, well, I will deal directly with those points, my lady, just to short circuit the process. There's two facets, I would say, to the question that's before the court on that particular point. The point is the whether or not the appellant should have provided all of the information relevant to the allegations that were made and the settlements that were reached when he signed and filed his application form.
That's not the question that Ms. Jill Francois put. It's really whether or not this application is misleading. Because what Ms. Daufrancois suggested in her closing submissions is that no, all of this information, all this kind of volume of documentation need not have been submitted by any means. However, a succinct statement, which could have been followed up by dialogue to, with the council, would have sufficed. Either way, this 2-page application form is grossly misleading as to what the real position was. And Dr. Qamar very well knew it. That's really what it comes down to.
Okay. So, I mean, going to the 2 questions that are in issue, I mean, you have question 3 and the question of whether or not it was truthful, whether the appellant's response was a truthful response.
Mm-hmm.
Could I take the court? I just want to refer to this is question 3 seems to have exercised the answer to question 3 seems to have exercised the court during my learned friend's submission. So I just want to go to what the evidence says about that.
Yes.
And it's if I could invite the court to turn up page 282 of the hearing bundle.
Yes.
Which is the second witness statement of Dr. Qamar.
Mm-hmm.
And this is, I'm really referring to this paragraph as a kind of lead into evidence that lies elsewhere, but I just want to make the point that Dr. Qamar does deal with this in his evidence by paragraph 8, by saying, and he's talking about his answer to, well, first of all, in paragraph 7, he's talking about his answer to question 3, and he says, her point, being Dr. Ross, essentially is that while my answer to question 3 was truthful, as at the date I signed the respondent's application form, I knew because I had entered into the 10 September 2018 settlement agreement concerning the administrative complaint that an automatic administrative sanction was ultimately entered against me because of my inability to re-enroll in Medicare. And then he says, however, as my healthcare, in paragraph 8, however, as my healthcare regulatory attorney, Tracy Mabry, makes clear in his witness statement, as at the date I answered question 3, not only had no disciplinary action been taken against me by the Florida Department of Health, but notwithstanding the terms of the September 2018 settlement agreement, it was still very possible that no administrative sanction would be entered at all because of the waiver. So that's what Dr. Qamar has to say. And he refers to the evidence of his healthcare attorney, Mr. Mabry, which is where I want to take the court now. And this deals more directly with the point that the court was considering. And that is at page 272 of the bundle. See, this is do you have it, my lady?
Yes, I do. Thank you.
So it's the witness statement of Mr. Tracy Mabry.
Yeah.
And the court's attention, first of all, if I may, to paragraph 4, where Mr. Mabry says, specifically, I want to explain how various matters that I handled for Dr. Qamar are related under Florida law, and to clarify that in answering the Bermuda licensing application, stating that there had been no disciplinary action or sanctions on Dr. Qamar's Florida medical license as of the 19th of October, 2018, Dr. Qamar's answer was truthful and correct as a matter of Florida law, and was specifically supported by the Florida Administrative Agency's own documents. So that's the first thing he has to say about that. But then he goes on in paragraph 18, which is at page 276.
I mean, but am I to give this a value that I would to expert opinion evidence? I can't do that, can I?
I wouldn't. No. This witness statement is not being submitted. Is not being submitted on the basis that Mr. Mabry is submitting expert evidence. I mean, the court can. He's
basically waiving privilege and saying that this is what he was advised, and this is why he did it.
Mr. Mabry is a highly experienced healthcare lawyer in the state of Florida. He is providing his evidence to the court. He's telling the court what the position is as a matter of Florida law. Obviously,
Well, yes, and so that would be expert opinion evidence. He's not an expert opinion for these purposes. So the most that I can treat this evidence, it would seem to me, is that this gives some insight as to why Dr. Qamar himself, in fact, responded the way that he did. He sought advice. This is the advice he obtained. He's waived his own privilege with his attorney so that you can see the advice that he obtained. And he's explaining that's why he responded in the way that he did. I'm not going to now I'm not going to treat him as an expert opinion evidence. Can't give this any sort of more expert opinion weight than I would Dr. Doherty. These are not independent expert witnesses.
Correct, my lady, and I'm not seeking to imbue Mr. Mabry's evidence with that weight. I'm simply pointing the court to the evidence that is there and providing. I'm seeking to provide a context and an explanation for the answer that was provided by the appellant in relation to question 3. Okay. And if I may, I'll just read Mr. Mabry's evidence on this point, and then I'll make some submissions on that. So,
right.
The final order. So he says at paragraph 18, the final order in ordering and implementing discipline was ordered and entered into the record on February the 28th, 2019. In Florida, the effective date of disciplinary action is not when a proposed settlement agreement is signed, or even the date of its presentation to the Board of Medicine for consideration, but is the date of the final order imposing the disciplinary terms and conditions. Both the settlement agreement and the final order state such as part of their standard terms. So all I'm seeking to make of that point is Mr. Mabry says that when it comes to, as a matter of Florida law, and I would suggest the appellant would have likely approached the question this way in the same way as Mr. Mabry in light of the fact that Mr. Mabry was advising him. As a matter of Florida law, it's not a disciplinary action, to use that term, is not regarded as being taken when a complaint is filed, or a settlement agreement is signed, or when it's only when the final order is entered. Now, we can get into a debate about what the term disciplinary action means, and whether action when one says has any disciplinary action been taken against you, does that mean the date on which the original complaint was filed? Is that a disciplinary action, or does that mean when sanctions are actually imposed, the action of imposing sanction has taken place? And I would say that there is room for debate about that, and there's also room for misunderstanding, and there's also room for different types of interpretation. So in light of that, I think it would be inappropriate and unfair to read from his answer of no to question 3 that he definitely understood that question to refer to the opening of an administrative complaint against him, which was not finally settled, and no disciplinary action had been taken against him, by which I mean no administrative sanction had been added to his license until February. And February of the following year. So that was a gap of 4 months, during which time he was seeking a waiver. And it's also important to, and again, the context is, when he was asked a specific question about it, he provided a truthful answer. So the appellant's case is that his answer to question 3, as at the time he was asked, it was correct. And then when he was asked questions about the settlement agreement and the date of entry of sanction on his license, by the early summer of 2019, he answered the question truthfully, and he provided significant amounts of documentation to explain and contextualize the position. And the irony, of course, is that of this case, if I could segue into this point, is that there's no allegation that any of the subsequent answers that Dr. Qamar provided were dishonest. The respondent's main complaint, sole complaint really, when it comes to this, is that, well, yes, you provided honest answers later on when we asked you specific questions about it.
The difference was that question 3 was dishonest.
Well, I'd also make the point, if I may, my lady, that's not what the respondent's evidence says. the respondent's evidence, and I took the court to the respondent's evidence yesterday, and I can dig up the references again if the court requires. But the respondent's evidence is that the answer that the appellant provided to question 3 was technically true. The first time that the respondent is now saying, well, actually, it was a matter of dishonesty, he was dishonest, it was in their skeleton. So there is a disconnect between what their written argument says and what the evidence of their witnesses say. The evidence of their witnesses is that his answer to question 3 was technically true. And you can argue about what technically true means, but they have conceded that it was technically true. But they're now, by a nuanced argument in their skeleton, they're saying, well, actually, that's not the evidence of our witnesses is not quite what we're saying. We're saying actually that answer was untrue, that was dishonest. So, my lady, in light of the evidence that I've showed you, and the light of the fact that one can see how there is room for some level of different interpretation as to what disciplinary action might mean in the context of a yes or no question on a simple application form, I would submit that that answer cannot be held against him. And in the appellant's mind, he was giving a truthful answer to a straightforward question.
Would you accept that the application form, when looked at it in its entirety, is misleading and does not convey the incredible tale of drama that Dr. Qamar was facing in the US?
I would concede that the answers provided to the screening questions and the documents provided by the appellant alongside his application form does not, of course, tell the significant tale of drama or woe that
or any part of it.
Indeed, that the appellant had been subjected to since around mid-2011. There's no, as a matter of fact, that is the case. It's a separate question as to whether or not that was misleading, and that is something we don't accept, because as we've said repeatedly in my opening submissions, when an applicant is faced with a short form application form, with the bulk of which is taken up by simple yes/no questions,
with an invitation to attach typed notes where a full answer is required.
Indeed, and and in relation to the specific section, a express direction to provide additional answers in the event of a yes answer.
Subject and to be read with the overall direction at the very beginning of the form, which says to provide answers, you give typed responses, full answers.
Indeed, my lady. And one can argue about how an applicant faced with this form should reasonably interpret what's on the form in front of him. The fact is, the appellant interpreted it in the way that he did. Mm-hmm. He then, when it became apparent to him, and this is a point that I raised yesterday, and if you recall that I took the court through the correspondence as between the parties between February and May of 2019. I mean, he in his mind, he answered the questions on that form truthfully. He anticipated that the application form would not be the end of the matter. Mm-hmm. In fact, he anticipated the application form would be the start of the process rather than the end of it. And as he had anticipated, the Credentials Committee of the respondent then conducted their own due diligence. I mean, that's what they did. They carried out a due diligence exercise. They Googled the appellant. They found out information about him, and they came back with further questions. That was what the appellant anticipated. And when he became aware of those further questions, and my lady will remember that there was some miscommunication, and he didn't become aware of those questions until much later. As soon as he became aware of those further questions, he instructed counsel, he provided fulsome and honest answers, and he provided voluminous documentation, which, as my lady has said, it stretches to over 1,000 pages. And as I said, the irony of the situation is that those truthful answers are now being held against him by the respondent, because they're saying, well, thank you very much for providing us with this fulsome information and voluminous documentation in 2019, but and we accept that that is all factually correct. But what we're holding against you is you didn't give it to us back in 2018, and that makes us think that you're not a good person, you're not a good character, and we don't accept that that was an appropriate finding to make in those circumstances. This is not a case, in contrast to all of the other authorities that have been placed before the court by the respondent, where a applicant is given a dishonest answer and that was the end of the matter. And there was an accepted and proven fact that the answer was dishonest and that the applicant had not qualified that answer in any way. This is not that case. There was a process followed. It took a long time, admittedly, but one can't see how reasonably the length of time that process took could be held against the appellant. And in the final analysis, he provided all of the information that the respondent required. And now the respondent is saying, well, thank you for all that information, but you didn't give it to us at first instance, so we are rejecting your application. My lady, if I could move on to, that's all I had to say about question 3. In relation to question 4.
How much longer are you going to be?
I'm almost done, my lady. I'm almost done, my lady. I would just say, the question 4 says what it says. It's plain words. It refers to the revocation of of privileges in a hospital setting. And the fact is, and this is not disputed, it's accepted, that the appellant had not had any privileges denied or revoked in a hospital facility. So his answer was truthful. And once again, the respondent admits that. But all the respondent is saying is, yes, you gave a technically truthful answer, but it was pedantic because you read that question narrowly. And you should have known that that question was referring to the revocation of any privileges anywhere in a healthcare setting. But that's not what the question says. And if that's the question that the respondent wants to ask applicants, then it needs to ask that question. It can't rely on an applicant second guessing what the respondent means by question 4. The appellant is entitled to read the plain words and answer the question straightforwardly. Now, my lady, the only thing I wanted to do, I had left to do, I mean, perhaps it's just, I can short circuit this by saying I was going to take the court through the respondent's authorities and explain why they can be distinguished on the facts of this case. I think in light of the desire to wrap things up, I'll just give a couple of headline points, and I've made this point again, is that when my lady comes to consider her judgment and my lady is reading the authorities relied on by the respondent, what my lady will be struck by in each of those cases is the fact that the appellants in those cases all had proven allegations of dishonesty or misconduct made against them. And again, that's not the case here.
Yeah.
So we say that all of those cases can be distinguished on the facts. I mean, that's really all I have to say. And I think that unless you have any questions for me, you wouldn't like me to address any other points. I think
No, I want to thank both you and Ms. Francois for very able submissions. I find myself very much assisted by your references and your thorough analysis of your respective cases. Clearly, I'm going to reserve. I should note that we have now approached December and the court calendar has been quite full and will be through to the end of next week. But I will have many judgments to write. And so the likelihood of me coming back with a judgment before the end of December is extremely grim and most unlikely. I would anticipate that you'll see a written judgment from me in the new year and hopefully before the end of January, but it will be in that time frame. If for whatever reason it should exceed that time frame, you will received some indication through the registry as to when I should produce a written judgment, but I can tell you that it is certainly my intention to produce a written judgment before the end of January.
I'm grateful, my lady. Thank you.
So I thank everyone else, and I think this is an appropriate point to adjourn, and judgment is reserved.
Thank you, my
Thank
lady.
you, lady.
I'm grateful.
Thank you.
Thank you very much.
Thank you, Dr. Qamar.
Thank you, Your Honor.
Mhm.